Your Honor.
Counsel, you and I have had metaphysical discussions more than 20 years ago
Oh, yes.
in my past career.
Yes.
And I've always admired your sincerity and the conviction with which you have stood your ground on many issues.
Thank you, Your Honor.
I also share your preference for some economists. And while I do believe in human capital, I see that your line of reasoning goes already to trying to craft a utopian society that has made policy choices that are not impaired by wrong decisions in the past and an unfortunate historical set of antecedents as this country has had. In other words, for all practical purposes, our government actually has choices on what kinds of ills it will address and what kinds of ills it will temporize on, and for the limited resources that it has to choose which to focus on. Now, this court is not the decision maker on the resource allocation that must be made by government. Do you agree with me on that?
I agree, Your Honor, but what we have come here for is not to question that wisdom or exercise of wisdom. What we're saying is that this honorable court has the duty under Article 8, Section 1 to determine whether, in the exercise of the discretion, Congress has violated the Constitution. That's all we're asking, Your Honor.
But when you're trying to juxtapose the philosophy on the primacy of labor and your reading of culture, of religious beliefs and everything, you have basically said that in the plethora of choices that are available to government, they had chosen one that offends and one that does not uphold other values that can be found in the Constitution. On the other hand, you agree that, of course, the right of parents to be responsible and make decisions on a fundamental matter as the size and timing of their offsprings is also of paramount interest to the state. You have basically decided that your path of a completely natural method that does not also promote an alien lifestyle, because you keep on referring to the United States culture as not compatible with Philippine culture. A way of life that chooses only natural means of family planning, that does not promote an alien culture, that continues to hope that somehow the masses of the poor will be able to find a savior among their ranks so that their families can be saved and be brought to the middle class. And you are projecting that it is therefore incumbent upon the state to ensure that this more natural means of progression, in fact a utopian kind of progression, is the one that is chosen. Is that the sense that we are getting from you?
Your Honor, you're right. Congress has many choices. Whether to accept one approach and discard the other, that's their choice. But the one thing that they don't have any choice is to violate the Constitution. And that's what we're saying. Now, with regard to the kind of family planning method a person would like to take, that is very personal. Even the Catholic Church respects free will. What we're objecting is a situation wherein the state, which under the Constitution is required under duty to protect the health of the people, is the very first to expose the population to the potential hazards of risk. In other words, the state, instead of protecting, is actually exposing the people to potential harm. I call it institutionalizing risks. And that is not the business of government, Your Honor.
Counsel, everything in life has a risk. In fact, the entire legal structure is founded on definition of risks, defining acceptable risks, weighing risks, and attributing liability for when risks are unduly taken when they should not have been. Is that not correct?
That's correct, Your Honor, for an individual. For a state, Your Honor, in case of risk, in case of doubt, because of the obligation to protect the health, shouldn't the state err on the side of caution by keeping a hands-off policy with regard to these issues and leave it to the individuals to decide for themselves? That's our point, Your Honor.
If the state says that part of the prevention of the risks arising from maternal mortality, which includes a long-term view, meaning the long-term viability of a healthy life for a female who keeps on bearing children, is part of the equation. Is that not the right of the state to weigh, meaning the executive and legislative branches of government? And it is not for us to meddle into the facts and try to find the kind of risks that they should be allowing or agreeing to allow.
Your Honor, I think whether or not a woman will use contraceptive is a very personal thing. It is like the state invading into the bedroom of that woman. And I think the choice...
Excuse me, not the bedroom, Mr. Counsel. Contraceptives are usually taken before the medicine cabinet, right?
Right, but
Okay.
they do it for a purpose inside the bedroom, Your Honor.
Well, whether they will have sex or not, sometimes it doesn't happen.
Yeah,
the woman
you're right.
just has to take it. Okay? So, when we talk about the right to privacy, let us be very clear and try to be clinical about it. The right to privacy on what happens in the bedroom is one thing, but the right to maternal health is another. Now, the state is saying we have chosen to prolong the life of the woman and give her a more viable life, productive, economic life, by allowing her the option to choose a method of contraception that is compatible with her beliefs. What is religiously coercive about that?
Not religiously, Your Honor, but...
No, but you have centered your entire argument on religious freedom.
Yes.
Now, I personally know many Catholics who do not believe that it is a sin to take contraceptions. Am I not, in fact, as a judge, intruding into her decision of what is violative of her religious freedom when she believes she can continue to be a good Catholic and take a contraceptive pill?
Your Honor, women who profess to be Catholics and yet believe that contraceptives are okay are not really practicing Catholics. They're not the ones who determine what the Catholic faith is. Because otherwise, any Catholic can simply decide how a particular faith, how the Catholic faith will be applied. I think there is an inconsistency. Because if we say we refer to Catholic faith, we refer to the doctrines, we refer to the teachings of that church. If any person claiming to be Catholic disobey or goes against that teachings, how can he ever say that he is really a Catholic? How can one say that he is Christian and yet not believe in Jesus? How can one say he is Muslim and does not believe in Muhammad? It's a contradiction in terms, Your Honor.
Okay. Now, if you are basically saying that those who choose to take contraception and who believe that they are not violating their religious faith by taking contraception are actually not genuine in their faith, then you're basically saying that you're arguing only from the doctrinal portion of the Catholic population.
Yes.
Is that now your position?
That's correct. Petitioners are speaking for the true Catholics, those who have deeply held beliefs under the Catholic Church.
Okay. Would you have an idea how many percent there are of those Catholics who strongly believe that taking contraceptive pills is a sin?
Probably these statistics would not be important, because what is important is what is in the heart of that Catholic, whether he believes that the magisterium and the teachings of the Church are what constitute the faith of the Catholic Church. Then that matters, not the number. So in other words, I think, Your Honor, it's not a question of quantity, but the quality, the sincerity of these people, it really believing in the central beliefs of the Catholic Church.
So the strength of your petition, counsel, is dependent on the doctrinal truism with which you hold on to the magisterium.
Yes, yeah, that's correct, Your
And
Honor.
all others who disagree with you, the Catholics who call themselves Catholics but who disagree with you, are basically not correct.
That's what we're saying, Your Honor.
Even if they believe that their religious freedom is not being violated by the RH law.
The problem, Your Honor, is that whether that claim of religious freedom is deeply held and based on a central belief, the fact that they're violating the beliefs of the Church will tell me that they are not holding deeply held beliefs.
Are they in sin or are they in ignorance, counsel?
Based on the catechism, based on the Catholic teachings, they would be in sin if they use contraceptives, Your Honor.
So you are basically saying now, if we choose to observe and respect the freedom of conscience of the Catholics, of the population who consider themselves as Catholics even though they take contraceptive pills, as against those who believe that it is a doctrine, a basic doctrine of the Catholic Church, that contraceptives is an evil. Okay. Are you not therefore arguing that your position is only for those sectors of your population that hold on to that particular and then therefore, counsel, if that is so, does it say that one who is a fervent Catholic is compelled to accept artificial contraceptives?
If he believes in the faith, yes.
Where in the law? Because now I am now being forced to narrow my examination to protect the rights of very doctrinal Catholics. Because you have already categorized those who believe that contraceptives, artificial contraceptives, is not a sin, or they are not genuine Catholics. So now I am going to focus my examination on the genuine Catholics. When are doctrinaire Catholics being coerced to take artificial contraceptives under the law?
Section 7, Section
How?
23.
Can you please read Section 7? When?
Section 7 says, Your Honor, I will go direct to that portion of the provision that infringes free exercise, Your Honor, if I may.
Yes.
It says here, the last second to the last proviso, that these hospitals shall immediately refer the person seeking such care and services to another healthcare facility. And then a similar provision can be found
Okay, let's read it so that we can take it fully and understand that if we are going to operationalize this law, it really means what you are trying to tell me it means. Okay? You're basically saying that all accredited public health facilities, okay, shall provide a full range of modern family methods, including consultation, supplies, procedures, and including services for those who are having infertility issues. Okay? But there is a proviso that even private health facilities, so this is the second part, I'm reading after the proviso, the first proviso. Family planning services shall likewise be extended by private health facilities to paying patients with the option to grant, except in the case of non-maternity specialty hospitals and hospitals owned and operated by a religious group. So that is the first. How many hospitals, private health facilities are now being operated by the Catholic Church?
I'm not sure about the number, Your Honor.
But they would number in the hundreds?
I can't hazard a guess at this point, Your Honor.
Okay, so that they are basically being asked, if they object, Then they go to the next proviso to the proviso. And the proviso to the proviso says what, Mr. Counsel?
That this private healthcare facility, acting obviously through its people, will have to refer the person seeking reproductive health services to another
health
healthcare
facility.
facility.
Okay, so the scenario is this. Someone will go to a hospital operated by the Catholic Church and is asking for family planning services, instructions. And the triage nurse, for example, this triage, I guess it's the triage nurse, informs this would-be patient that only natural family planning methods are available. Is that what the scenario here?
That could be a scenario, Your Honor.
Okay. And therefore, if the would-be patient says, but I want a modern method, can I not have the benefit of information and access to a modern method? Can the triage nurse not say, please go to this hospital, to X hospital? Is that a violation of a religious freedom, Mr. Counsel?
Yes, Your Honor.
Why? Why can that triage nurse, speaking on behalf of the hospital, not simply refer it to another hospital? Does it say that the triage nurse is prohibited from saying, if you use modern family planning method and you are a Catholic, you are committing sin? It doesn't say that.
It says in the Catechism, Your Honor, if I may read.
Okay.
It says here, anyone who deliberately leads others to commit serious sins himself commits a grave offense. That's one provision in the Catechism. There's another provision, Your Honor, if I may. It says here, to the question, do we have responsibility for the sins committed by others? The answer in the Catechism is this. We do have such a responsibility when we culpably cooperate with them. In other words, applying the concept of formal cooperation or material cooperation as implied in these two rules, that conscientious objector will actually commit a grave offense if he refers that person to another healthcare facility.
Okay. Can that person not say, the law requires us to provide you information on another healthcare facility? And the triage nurse draws up a list of other health facilities. Is that a sin?
I think so, Your Honor. Because that would be leading him as well to commit a sin, following this doctrine.
You are leaving basically the triage nurse under the Catholic doctrine only two choices. To keep either completely silent or to say and rebuke the person, but you are committing sin.
No, he
They are going to ask for a modern family planning method. Is that what a conscientious Catholic would do under the situation?
She could or he could just keep quiet, Your Honor. There is no law that will compel him other than this RH law to promote or speak up about contraceptives because, as I said, it will violate his religious faith.
So you're saying that in the situation of Section 7, the only way that the personnel of a private health facility can uphold his religious freedom, his religious belief as a Catholic, is to keep quiet. And the fact that that person is being forced to keep quiet because of Section 7, that is a violation of religious freedom.
Yes, if he keeps quiet, he'll be liable under Section 23, Your Honor. In other words, sorry.
Okay, so we jump to Section 23. Okay, kindly read the relevant portions that you are referring to.
I refer, Your Honor, to Section 23A3.
Okay.
It says, refuse to extend quality healthcare services and information on account of the person's marital status, gender, age, religious convictions, personal circumstances, or nature of work, provided that the conscientious objection of a healthcare provider based on her ethical or religious beliefs shall be respected. However, this is the
this is an objectionable portion for you.
Yes, Your Honor.
Okay.
The conscientious objector shall immediately refer the person seeking such care and services to another healthcare service provider within the same facility or one which is conveniently accessible.
Now, in the principles on the drawing up of the guidelines, the law is very careful to ensure that the freedom of belief is followed. If the IRR allows the conscientious objector, the conscientious facility provider, for example, to not even be forced to refer, will that already cure the problem?
I think
for
so.
you?
That will remove the infirmity.
Okay. So the important point is that the conscientious objector not be forced to refer to any healthcare facility, regardless of whether or not that facility might even provide the same kind of advice that you have.
Yes, sir.
What if that healthcare facility refers that person to just another Catholic healthcare facility?
Yes,
Will that not be also compliance with Section 7 and Section 23?
You mean the third healthcare provider eventually?
Yes.
Okay.
And then, in other words, does it say that all healthcare providers be listed? Can the conscientious objector not just choose to just also refer them to the inquirer to another Catholic healthcare facility? Can that objector not do that?
Not to refer him?
No. Refer that inquirer to the another Catholic healthcare facility.
No, that will be part of the objection, Your Honor. The law accepts
the objection. The objection is the fact that you are required to refer, regardless of your idea on what kind of advice will be given by the referred to facility.
That's correct, Your Honor. Because it's like leading him to sin. Remember, the basic premise is that contraceptive is inherently immoral and evil.
The idea is because that inquirer is looking for advice on the use of artificial methods.
Yes,
that's
Your Honor.
it.
Yes, Your Honor.
Okay. So it is the fact that you are going to advance the cause of artificial contraception in any manner, including the reference to another facility that is objectionable from the Catholic point of view.
That's correct, Your Honor.
Okay. So if this is mitigated or tempered by the IRR in such a way that those who you consider as genuine Catholics are not forced to refer, that will cure the infirmity in the law.
But the law is still...
No. Only with respect to 7 and 23.
If the effect of the IIR is to overturn the enabling law, that would be okay, Your Honor. But if it's just the implementing rule, but the law itself requires the duty to refer.
No, but the law has a lot of provisions there which are very respectful also of the freedom of conscience of persons here. Everywhere it says that coercion is never going to be used. So the IR can look at this as a coercive measure and it can very well provide a way out. Will that cure the situation?
The law is still not cured, Your Honor. That's a problem, unless they amend it. But if it's just through an implementing rule, there is still a doubt as to whether or not the implementing rule can amend the provision of the law itself.
Now, this is in connection with, this is not really my question. I just want to clarify something also in Section 23. Can you please refer to A2 II. 23A2II. Okay?
Okay, yeah.
A2 is premised on the performance of the legal and medically safe reproductive health procedure on a person of legal age. Right?
Yes, Your Honor.
And there was a comment earlier by one of us that actually even procedures are going to be performed on minors because of II. Do you not think that II is subsumed by 2, which requires that the procedure be conducted on a person of legal age? In other words, we can consider II as a surplusage, but it does not give a separate ground for invalidity. Is that correct?
That's correct, Your Honor.
Okay, that's a correct interpretation. Okay. Now, in connection with the Equal Protection Clause, I have yet to look and find any case in the world that says that when the state is unable to address all medical problems simultaneously, then the state has run afoul of the Equal Protection Clause. Because I've tried to look closely at the proposition that you are forwarding. Is this really something that you continue to hold on to? That all the medical problems of the poor are to be attended to equally, including the medical problems of the rich, because you mentioned diabetes. Is it something you still continue to hold on to?
As a basic premise, Your Honor, if we concede that all men, all people have the right to life and the right to health, and if we assume that the state exists to make sure that all who enjoy the right should be treated the same way,
okay,
then there could be a problem if Congress would choose to cherry pick, and having done so, would do so in a very obvious way that you see that the serious problems are not taken care of, while the not so serious problem are taken care of. I think that's what we're saying here, Your Honor, that you have a situation wherein the government would pour in billions of pesos. And if the idea is to prevent or reduce maternal deaths of 160, which is less than 1%.
You are already entering the question of wisdom, correct? And this court is not the representative of the people. It is there in Congress, where more than 200 representatives in the lower house and 24 in the upper house debate day in and day out, claiming representation of the people. We do not claim to be representatives of the people. We only abide by what we see the Constitution to provide for. And in that sense, therefore, we're able to guard the rule of law even against the dangers of populism. But what I am saying is that wisdom, which you are already tracking us to, is a prerogative of Congress, and that has never really been set aside. Unless now you are going to arrogate unto us the role of a super body.
The principle of equal protection, Your Honor, is written in the Constitution.
Yes, so equal protection. Try to look for a situation anywhere in the world, anywhere in history, where a court has ever compelled the state to attend equally to all needs.
What we think, Your Honor, is Congress...
Even the richest country in the world cannot even do that.
Yes, but they probably would start with...
What more a country like us? So the solution is get more people who think like you elected into Congress, so that the right priorities can be set as you see fit. Correct? But it is not up for us to cure the problems that you see that Congress has generated by choosing one priority over another. The solution is to elect the people who you think represent the correct values.
Yes, but that is only one of many
objections. That's a political solution. That's not a legal solution.
Yes, Your Honor, but again, I submit that it is the duty of this court to be able to ascertain whether...
How can we choose over diabetes, a cardiovascular disease?
No. We're not asking this court.
A lung problem, another health-related measure, because they are saying that this is a health-related measure. They even use the word health. So if it says it's a health-related measure, how can we say that the health-related measure that benefits us, justices of the Supreme Court, who have many of those diseases that you were saying should be attended to should receive preference over what Congress has said is a more important health measure.
I think it's basic in the exercise of checks and balances for this court to be able to look into the arbitrariness of particular legislation. But going beyond that, Your Honor.
Okay, arbitrariness. Now this, I am very curious. How can you raise arbitrariness if this has been debated for 14 years?
You know, the fact that it has been debated.
Arbitrariness have something to do with something being plucked out of thin air.
Or
something that has interjected itself artificially into the timeline of the natural course of events in an institution. But if something like this has been germinating in Congress for 14 years, it is difficult for me to just come in and say, Congress has arbitrarily exercised its powers. They must have already had more permanent enemies with each other for all these years, and they have fought long and hard over this. It's difficult for me to say that they were arbitrary. So why are you saying that there is arbitrariness? And you've had many of the lawyers and litigants of your side have actually participated in the debates in Congress. The outcome is something that we do not control. So how can you interject the argument of arbitrariness?
Arbitrariness can also arise if Congress, in the exercise of its legislative power, would actually, as I said, cherry pick to a point where...
What is cherry picking? Can you tell me how people cherry pick? Oh, let's imagine cherry orchard. Okay. What is cherry picking?
Cherry picking in this particular instance.
So that it becomes legally relevant.
It becomes relevant if...
Yes. Is it similar to a lottery?
Probably for them.
So it was lottery that attended 14 years of debate.
What we're saying is something like this, Your Honor. The law will require the disbursement of at least 3 or 4 billion pesos. And it's a given that we have limited resources.
How much did the Pinoy, with all due respect, the President, announce would be the budget he was going to submit to Congress?
I think it's something like in the trillion.
2.3 trillion. Okay, 3 billion. 3 billion is a fraction of 2.3 trillion. Can you compute, please?
3 billion.
It is a little over 1 over 100. Or even 1 over 1,000. Okay. 14 years of debate. 3 billion budget. In a 2.3 trillion national budget proposal. How can you make the case for a lottery type of decision?
By looking at it from a different perspective, Your Honor. With 3 or more billion, you can build a lot of hospitals. You can train more poor people. You can actually provide free medicine for tuberculosis.
But all of those, I heard it in the SONA yesterday. A lot of hospitals were going to be built. A lot of schools were going to be built. A lot of healthcare facilities and healthcare services were going to be expanded. So you cannot say that of all the medical needs of the population, this received priority over the others. I didn't see that in the figures unless there was magic in the President's PowerPoint presentation.
Yeah, I agree that he will build more hospitals, but with 3 or 4 billions or even more pesos, that would add up to the hospitals that will be built. The point, Your Honor, is that if you have limited resources, if you have a budget in the House, wouldn't you prioritize?
But I thought that a budget bill is basically a bill of priorities. So the GAA, if it contains 2.3 trillion, already has priorities. And the only way you can really argue that this RH law is an arbitrary, cherry-picked, lottery type of allocation, if you can show disproportionality in the budget allocation for other health services and other health facilities and other pro-poor facilities vis-a-vis what is going to be given to the RH law. That is the only way you can do that. Because your statements of the lack of arbitrariness also is related to a question of an attempt to say that there is a lack of proportion. The means that the government has chosen is a sledgehammer type of legislation that goes through a massive information campaign, targeting the wrong sets of people, giving the wrong sets of solutions. On the other hand, the correct solutions are being completely ignored. Your earlier statements actually indicate to me that you think you could have done and crafted a better budget proposal than the President's team, because you would have made a better allocation of the budget for the poor. But yesterday's 1 hour and 45-minute speech actually enumerated a lot of his supposed intentions to provide services to the poor. Do you think that there is not a lack of balance in the way you are phrasing the issues here?
Your Honor, the 3 or more billion pesos, I think, would be in addition to what the DOH will provide in its general appropriation. In other words, our point is that is one of the many issues that affect this particular law. We also raise constitutional issues that they will have to overcome.
So you are now going to abandon this line, because I am happy if you will abandon this line, because I don't think you can prove your point here. You want to go into a debate on the proportionality of the attention to the RH law vis-a-vis the other kinds of services. You're going to go into a hornet's nest that you cannot extricate yourself out of. You'd better just go back to your original discussion on religious freedom. Okay? So, let's go again to religious freedom. Justice Telly has already told you that there are several portions in the religious clause of the Constitution. Now my worry, because you are basically saying that it is the doctrinal portion of the Catholic Church that is very strongly against this, on the argument that this is a violation of the Catholics' religious freedom. Is this not already skirting on state interference with the secular state, religious interference with the secular state policy, really in danger of infringing the non-establishment clause?
Your Honor, our objection does not fall under the non-establishment clause, which guarantees equality between believers and unbelievers. We're talking of the second part, which is the free exercise. We're saying that Section 7 and Section 23A3, because of the coercive nature, imposes a heavy burden on the exercise of our faith.
Okay, let's say we assume just for now we're able to cure 7 and 23. Okay, let's go to your equal protection problem and your religious freedom problem with sex education in schools.
Yes, Your Honor.
Okay. You're basically saying that the poor are going to be, because they go into public educational institutions, are going to be discriminated against because, first of all, they will have a heavier burden.
For the students.
For the students. Can you go to the section of the law that provides for sex education, please?
That's Section 14, Your Honor.
Okay, let's go there. Okay.
The state shall provide.
You had been saying they will be coerced. Your religious freedom proposition went like this. They will be coerced, unlike those in the private schools, because they will have to go through this. 14 only says that the state shall provide the education. Where does it say here that if the parents or the student objects to the provision of sex education, they cannot opt out of their classes? Where does it say in 14?
In the last sentence, Your Honor.
Okay. Provide a curriculum.
Which
there are elective portions of curricula and there are non-elective portions of the curricula. Does it say that this is a mandatory portion of the curricula?
I think it does, Your Honor.
Why?
Because of the use of the term shall be used.
The
And
shall
that
is a
this-
formulation. The mandatoriness of the curriculum is not related to the formulation. The formulation is mandatory on the part of the DepEd, but whether it is coercive on the part of the students to have to enroll in such classes is not provided for in Section 14.
I think it is.
How?
It says here, shall be used.
Oh, so the DepEd can use it. But
Yes.
what I'm saying is that if a student does not wish to attend this class, can he not refuse to attend this class?
He will fail. Because
What
it's
does it say?
integrated. It's integrated in all the subjects.
You know, you go to the middle portion, please. Okay? Provided flexibility in the formulation and adoption, even adoption of appropriate course content, scope, methodology shall be allowed only after consultations. In other words, there is a prohibition on the part of the state, on the part of the DepEd, to implement anything that has not received the consensus of the community. We have had so many curricula where students can opt out. We even have home-based education. I don't think the DepEd will be as arbitrary as to say that you will fail if you refuse. Your children will fail if you refuse to allow them to attend sex education classes. I don't see coerciveness here. I see a policy direction given to the DepEd and a formulation of a process by which the DepEd can implement that, which is only after consultations have taken place.
If that will be the interpretation of this honorable court, then I think it will help make that provision acceptable. If the interpretation of the court is that there is no compulsion and that any parent can opt out.
You know why it's easy for us to interpret it this way? Because everywhere the law is replete with the respect for the freedom of conscience. So we just take that into consideration and we already have an easy way of interpreting Section 14.
If that would be the interpretation, Your Honor.
Okay. Now, does the reproductive health law encourage the failure of regulation by our Food and Drug Administration? Does it? Because he kept on saying that there are so many risks. The information will not be there. Information will not be disseminated. Is there anything in the law here that gives us a clue that that is the intention that is going to be given to the FDA?
Well, there is an indication in Section 10, Your Honor, Section 9.
Can you read it, please?
It says, the National Drug Formulary shall include hormonal contraceptives, intrauterine devices, injectables, and others safe. If you read the text of the provision, it seems to qualify safe. It seems to use safe as a qualification to the preceding enumeration, which means that this law, Section 9, already makes a conclusion.
Okay. In Attorney Noche's argument last time, she considered that conceptually there can be hormonal contraceptives that only take the first two actions and does not fulfill the third action, which is to prevent implantation. Now, we cannot find out among the pills that are there which can perform two actions or which can perform three actions. Okay? We cannot. We're not doctors. We're not biologists. We're not pharmacologists or whatever. We're not chemists. So, if this is so, can you please also read for me Section 19, the DOH, for example. 19 B1 3C Section 19. Okay, let's go one by one. B1 first.
P1.
The DOH. You start with
The
DOH.
DOH, in coordination with the PHIC, as may be applicable, shall 1. Strengthen the capabilities of health regulatory agencies to ensure safe, high-quality, accessible, and affordable reproductive health services and commodities with a concurrent strengthening and enforcement of regulatory mandates and mechanisms.
Okay. Ensure safe, okay, reproductive health services. You had made much of the point that there are so many health risks that are associated with artificial contraceptives. Now, the DOH is mandated to ensure safety of the users of any method that they are going to accredit. Okay? You go to B2-3.
B3, Your Honor.
Yes?
Engage the services, skills, and proficiencies of experts in natural family planning, which shall provide the necessary training for all BHWs.
Okay, see, there is no bias that I see against the natural method here. They are required, in fact, to engage the services. They are required to hire experts on natural family planning. So this is not as if there is going to be a mass distribution of pills, because they are required to at the same time engage experts who will teach the people about natural family planning. Now let's go to C.
C.
Also of the same section.
The FDA shall issue strict guidelines with respect to the use of contraceptives, taking into consideration the side effects or harmful effects of the use.
Okay. Strict guidelines. Notice, FDA shall issue strict guidelines with respect to the use of contraceptives, taking into consideration the side effects or harmful effects of their use. This is a statutory duty on the part of the FDA. Earlier, you were talking as if the law wants to destroy the health of women. Now, you have here a very clear statutory duty under the duties and responsibilities of several government agencies on what they must ensure. This is clear. So it is not as if the harmful effects are being ignored at all. In fact, even a painkiller has side effects, even on the liver. Even an ordinary painkiller. The most ordinary medication, maintenance medication that we are taking now, all of us that you admitted, in fact, to taking, all of these have side effects. And the FDA is required to make sure that these side effects are taken into consideration. So that guidelines need to be strictly provided. So I don't see anything in the law that says that we should be insensitive to the consequences of women as long as they do not become pregnant. It's okay, give them contraceptives, even if they get cancer in the process. I don't see that, Mr. Counsel.
Yes, Your Honor.
Not at all in the law. It is the law that we are talking about. So what would I trust? My judgment on the health risks of these drugs on women? Or I would rather trust FDA, before whom you and everyone who believe that contraception should never be provided to the population if they're artificial, you can go there and argue that these are unhealthy.
2 points, Your Honor, if I may.
Okay.
First, Section 9, if it's read on its text, appears to preempt the exercise of discretion on the part of FDA. Number 2, in the U.S., before a physician could dispense a contraceptive, the law there requires certain procedures and examination.
Why don't we require that to be put in the guidelines or in the FDA? Why don't you argue that, please, in the prescription, in addition to the other kinds of things that must appear there, you have to provide all of the question and the checklist. In other words, it's like a punch list, a construction punch list, right? Why don't you argue that there be a construction punch list similar that is applicable in this situation?
Because in terms of logistics, in the States they have, because what's required there are skilled, meaning physicians who are actually experts, meaning if you need an OB-GYN, then
So
you'll get
let
that.
it be there
But
in the
we don't have it.
guidelines. Let it be there in the guidelines.
Under the law, they will harness midwives, they will train even non-medical people to provide these services. So in other words, there's no, in the law itself, there isn't any safety net, there isn't any control mechanism that would ensure the safety of the health of the users of contraceptives.
Go to section 22.
Yes, Your Honor.
Okay. There is a Congressional Oversight Committee. Congress has been talking about this for 14 years. Why can we not entrust this matter to Congress again? That they will provide for whatever safety net. Because you have been arguing on the fact that this law is not comprehensive enough. There is never any law in the legal firmament that is sufficiently comprehensive to address all ills. And we have never struck down a law because it is not sufficiently comprehensive. Even if they call it comprehensive land reform, they cannot make it comprehensive enough.
We're questioning the law on constitutional grounds.
No, you had argued that it is so insufficient that it must be struck down. I am saying that Section 22 provides you your step forward. We don't have an actual case here. What we don't have here is an actual case where first the FDA's metal has been tested, where it approved as accredited an abortifacient when it should not have been granted such an accreditation. Okay? We have not had a test case here where there is a health worker that has been trained by the DOH that has provided to be an incompetent service provider. We have not yet had here before us an instance when the Congressional Oversight Committee has even reneged on its statutorily imposed duty of making sure that the safety of women is provided for. We don't have that. In other words, what we have are fierce speculations to go on.
We also have violations of the Constitution, Your Honor.
Well, you have already said that it violates the religious freedom of those who are very strict about adherence to the magisterium. And that is duly noted. How you argued it, we already fully understand how you are arguing it. But what I am saying now is that perhaps you have not seen other facets of the law that provide for a balancing in case there is a lack of a solution to a particular problem. In other words, your arguments have been mitigated. I see Section 22, I see Section 19, I see a way of reading the other provisions that you are complaining about, because I'm going to use as interpretative mechanisms the other policies that are replete in the entire law which tries to protect the health of the mother, and I see that there is a way that these can all be balanced off. What I am afraid of is that you are going to ask us to make a ruling that it is violative of the freedom of religion because the law violates the magisterium. And I'm saying now, where under the Constitution can we draw the line that will connect us to make such a legal conclusion from the magisterium to a judicial decision?
We would just like to clarify that it's not because it violates the magisterium that the Constitution is unconstitutional. It is unconstitutional because it impedes the free exercise of religious rights flowing from that magisterium. Okay, so if we make a conclusion here that the conscientious objector will have to be found a way out by the government, that will already do away with your argument on religious freedom. Correct? Insofar as those two provisions are concerned.
Yes. Okay? With that, I have no further questions.